In the wake of a loss, families often find themselves buried under unexpected paperwork and frozen bank accounts. Without a clear plan, this administrative weight creates intense stress during an already difficult time. Dying without an estate plan leaves your legacy to the default settings of the law. In this scenario, the state dictates exactly how your assets are distributed, regardless of what you might have wanted. This lack of direction leads to predictable friction. Relatives are forced to settle your affairs through guesswork, which often sparks painful arguments and long legal battles over your intentions. Establishing a clear legal roadmap changes that dynamic entirely. It replaces potential chaos with a set of organized, actionable instructions. Viewed this way, estate planning is a project in information architecture and friction reduction. It is a service you provide to your family to ensure clarity, no matter the size of your bank account. Most people recognize the need for a plan, but the wall of legal jargon makes it overwhelming to start. We can simplify the path forward by looking at the actual trade-offs involved. Doing nothing requires zero effort today, but results in the lowest family outcome, maximum state control and delays. Implementing a will or trust takes moderate work now, but guarantees they receive the highest level of protection and clarity. Your specific path forward depends on the amount of administrative burden you want to lift off your family's shoulders. You are essentially trading a brief time investment today for the total protection of the people you care about tomorrow. The most common starting point is a will. This serves as your baseline legal document for providing your family with a roadmap. Its first function is to explicitly assign your assets, ensuring your property and accounts go exactly where you intend. Second, it allows you to legally name guardians for your minor children, providing them with immediate security. Third, you use it to appoint an executor, a specific person responsible for carrying out your wishes. However, a will operates within a specific constraint, a process called probate. Probate is a mandatory public court process that validates the will. Because it involves the court system, it can delay your family's access to funds for months or even years. A will provides a social direction, but it still requires your family to navigate the slow speed bumps of the public legal system. A trust offers an alternative path. It is a private legal arrangement that operates independently of the court system. The core mechanism here is speed. A trust allows assets to transfer directly and immediately to your beneficiaries, without waiting for a judge's approval. This bypass provides maximum privacy, faster access to inheritance, and more comprehensive control over how and when funds are distributed. The trade-off for this speed is a slightly more hands-on setup process today, as you must organize your assets into the name of the trust. This makes a trust particularly helpful for homeowners, parents of young children, or anyone who wants to avoid court involvement entirely. By front-loading the administrative work now, you grant your family a frictionless experience later. To decide which is right for you, we can look at how these two instruments compare side by side. Regarding asset transfers, a will is delayed by the courts, while a trust is immediate. For naming guardians, both documents successfully provide the legal authority you need. When it comes to the legal system, a will guarantees probate. A trust avoids it entirely. This affects your privacy, as a probated will becomes public record, whereas a trust remains strictly confidential. A will offers a simpler upfront setup for you, but leads to a slower resolution for your family. A trust requires more upfront organization from you, but delivers complete control and speed to your loved ones. The right choice depends on the specific volume of red tape you want to clear out of your family's way. Even with the benefits clear, action often stalls because of a common misconception, the idea that you don't have enough money to justify a plan. Securing a guardian for your children or directing the transfer of a modest home is about providing direction, not managing massive wealth. Many people also fall into the procrastination trap, assuming they will get to it someday. Most wait too long, leaving their families exposed. Others assume the legal process is simply too complicated to start without a team of expensive experts. Today, logic-based software and digital templates handle the complex document drafting that used to require weeks of manual legal work. These advancements have made the entire process simple, fast, and affordable for the average household. Waiting for a more convenient time or a higher net worth only leaves your family at risk today. Finalizing your instructions provides an immediate reward, profound peace of mind. Whether you choose a will or a trust, you are building an organizational barrier that protects your family from the unknown. Legally binding instructions eliminate guesswork, which is the most effective way to prevent future family conflict. Proactive planning is a profound act of responsibility and love. You are ensuring your family faces a clear path rather than a legal maze. When you take a few minutes to plan today,